Welcome to Module 3, Video 4 from the Safe and Effective Use of AI in Education online resources. In this video, we will explore the importance of data protection and intellectual property when using student work with generative AI, as well as other considerations. When using generative AI tools, we must remember our responsibilities in protecting the rights of the students and pupils we work with. There are two distinct areas that need to be considered: children's personal data, as protected by UK GDPR, and their intellectual property. These require separate processes of consent and permission, as set out in the DFE's AI policy paper. Children require specific protection as they may be less aware of the risks and consequences of generative AI on their rights to their personal data. You can pause now if you need a reminder of what falls into these two categories. This means we must raise student and pupils' awareness of data protection by being transparent, telling them when and how generative AI systems will use their data in clear and simple language that they will understand. Being open about the data protection risks and safeguards involved with the use of generative AI systems, and letting them know what to do if they're unhappy.
The Generative AI and Data Protection in Schools guidance helps schools understand AI-related risks and biases to personal data. It provides tools and resources to address potential data protection risks and helps schools ensure appropriate levels of protection are in place for students and pupils' data. Children have the same rights as adults over their personal data under the UK General Data Protection Regulation, or UK GDPR, and the Data Protection Act 2018. Under this, and alongside other rights, children have the right to be provided with a transparent and clear privacy notice, which explains who you are and how their data will be processed, be given a copy of their personal data, have inaccurate personal data rectified and incomplete data completed, exercise the right to be forgotten and have personal data erased. Where a school decides that consent is an appropriate lawful basis for processing data with AI, the UK GDPR also states that is relevant, in particular where the data subject has given his or her consent as a child and is not fully aware of the risks involved by the processing and later wants to remove such personal data, especially on the internet. The data subject should be able to exercise that right, notwithstanding the fact that he or she is no longer a child.
What does this have to do with generative AI? Well, we know that generative AI systems are trained on huge data sets. In some cases, as well as that initial training data, the system continues to be trained through the data that users input into it. As a separate issue to data protection, it's important to recognise that the intellectual property, or IP, of work produced by pupils or students belongs to them.
Therefore, to avoid infringing intellectual property rights, we need to follow the DFE's Generative AI in Education guidance that states schools and colleges must not allow or cause students' original work to be used to train generative AI models, unless they have permission or an exception to copyright applies. Permission would need to be from the student as the copyright owner, or the student's parent or legal guardian if the copyright owner is unable to consent because of being a minor. Exceptions to copyright are limited, and settings may wish to take legal advice to ensure they are acting within the law.
Let's take the example of generating feedback on student work. A teacher might paste pupil or student work into a large language model, or LLM, to generate feedback. The work that the pupil or student has done remains their intellectual property. There are several potential issues in this example. The AI could learn from the data inputted, and therefore incorporate the student's work into the model. Without permissions in place, this would infringe copyright law. There is also the need for transparency in any use of AI, especially in such a crucial area as feedback to students. We also need to be particularly careful to check the quality of the feedback and adapt it. Even if we know we are using a safe tool, have permissions in place, and are being transparent, we must always maintain human oversight of this process.
We strongly recommend as an educator you only use the generative AI tools provided by your institution. This is because the designated data officers, alongside the relevant members of leadership or management, should have conducted the necessary checks to ensure appropriate privacy protections are in place for students and pupils' data, which may include a data protection impact assessment. Free AI tools often don't have these safety considerations in place and require careful consideration, bearing in mind the Department for Education's product safety expectations. Enterprise or professional AI tools incorporated into suites of secure tools for schools and colleges are much more likely to meet these requirements. The legal landscape is still evolving around the way that large language models work, and we need to consider that copyrighted material may have been used in the training of the model, meaning that there is a potential for the output to resemble or contain copyrighted material.
This is known as secondary copyright infringement. We can reduce the risk of intellectual property infringements by avoiding public sharing, for example on a school or college website, of any content largely created by a generative AI tool. You can pause now if you'd like to look at the statement on this from the DfE's Generative AI and Education Policy paper.
In addition to pupils' or students' work and AI-generated work, schools and colleges often use copyrighted materials, and there is a risk in using these with AI systems. For example, when we are creating learning resources, we must not share copyrighted material with an AI tool without the permission of the copyright owner, as this may infringe their intellectual property rights and may be irreversible if the AI system learns from the input. AI tools are becoming more integrated into systems, and that can make it difficult to identify the data that is being used by the integrated AI, which highlights the importance of schools and colleges regularly reviewing the approved tools. There is more advice for leaders on this in the Leadership Toolkit.
So to summarise, always remember to only use generative AI tools that are approved and provided by your setting for work purposes. These should meet the DfE's product safety expectations and keeping children safe in education guidance requirements. Be particularly careful when working with student data and/or intellectual property, only using it in an approved way while respecting pupils' and students' intellectual property and data rights. All tools should have a data protection impact assessment completed, and permissions need to be in place regarding the use of intellectual property. This includes, but is not limited to, pupil or student work. Personal data should not be entered into AI tools unless you have been advised that it is safe to do so by your data protection officer and a full impact assessment has taken place. Be aware that, depending on the generative AI system used, the prompt you enter may not be private and could be used to train the model. This can be especially the case in free versions of tools or those provided as a personal account outside of your school or college's approved suite of digital tools, highlighting the importance of only using the approved tools. We should always be transparent about how we are using generative AI as educators. Education settings should ensure they have a lawful basis or consent adhering to UK GDPR for processing data, and they need to be particularly careful when using data in AI tools. Education settings should also ensure that they have the correct permissions in place to avoid infringing intellectual property.